Welcome to Legal 123s with ByrdAdatto. Legal issues simplified through real client stories and real-world experiences. Creating simplicity in 3, 2, 1.
Welcome back to another episode of the Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd.
Thanks, Brad. As a business and healthcare law firm, we are often immersed in the heavy details of a particular issue or project. It's beneficial, if not mandatory, to every so often take a step back and evaluate the bigger picture. This season's theme is Zoom Out. We have all been immersed in life of a global pandemic, and we're going to make sure with each story this season that we step back, look at how the issue we discuss will be impacted by and in our new normal.
You know, Michael, I'm really excited about today's episode because we get to have movie talk again.
You really should have started your own podcast on movies. It would have to be a really niche movie podcast focused on 80s and before, because that's really what you like to talk about.
You know, that makes sense. If it's 80s before, I could actually call Brad Buster's movie review, and only the people for the 80s would even understand what the Busters part was about. But I could conceptually see this being a billion-dollar concept. Mm-hmm. Spotify probably signing me like Dax Shepard or Alex Cooper or Joe Rogan to exclusively be on their sites. But today, we in our movie talk, we get to discuss the impact of a famous line which they said, "Greed is good."
Vintage 1980s, Brad. You did not disappoint. Mm-hmm. For those not tracking and as old as Brad and I, this is from the movie Wall Street, where Michael Douglas played Gordon Gecko, a super wealthy corporate raider who had many unscrupulous tendencies. And I do remember, Brad, a line, "Blue Oyster loves Anacott steel."
All right. Well, hold on, Michael. In my defense, they did do a follow-up to this movie in 2010 where Gordon Gecko, spoiler alert, got out of prison and was back to some of his old tricks again.
Yeah, that's not compelling at all. Objection overruled. So where are you going with all this?
Well, Gordon Gecko owned and ran his own hedge fund in this movie, and that meant he was buying companies, obviously trying to buy low, sell high, or take the companies apart piece by piece. Plus, he may have done a little inside trading to get ahead of the game, which I still think might be illegal, but or frowned upon. But of course, this no way represents what the hedge funds or private equity are doing in today's industry. So let's fast forward out of the movie world of the 1980s into the real world where private equity is actually constantly seeking different industries. But Michael, they've definitely been heavily involved in the medical industry.
True enough, Brad. I mean, they've been dominating in certain markets like pharmacy and skincare, labs, imaging, ambulatory surgery centers, and hospital systems. And I think where you and I even see it more, impacting our client base is over the last decade, moving into the services side, the practice of medicine side, like dermatology or dental practices has a robust private equity presence, optometry, pain clinics, medical spas. And really, you and I both noticed, as partly the inspiration for wanting to bring it up in a few different episodes now, is during the pandemic, we've seen an increase in calls from private equity wanting to understand better the kind of surgical practice. And, just to name a few, we've seen it in retina, spine, and plastic surgery practices.
Yes, all correct. So today's story will focus on the impact private equity had on one of our clients. And we will learn, did our client actually partner up with Gordon Gecko or just another private fund looking to make an honest buck?
Well, Brad, so you ran point on this file. So, give us all some background before we kind of get into the deal points.
Yeah, so our client was a well-respected surgeon. He was in the late 60s. He's actually married to another physician. And on top of this, he actually had done very well financially, invested wisely, and so he was pretty well off. But he was just a sole provider. He had no plans of ever bringing on another physician, much less selling his practice. And so but his practice, it was extremely, had a very, his subspecialty that he practiced under, there's only a few physicians in the countries that actually provide these same surgeries. So today we'll call our client Dr. Bud Fox.
Well, first, and we'll get to this more later, but it sounds like he had the classic, what we call drop mic plan for retirement. Just close him down one day. He'd got it all built up. Well, we'll talk more about that a little bit later, I'm sure. But first, why Bud Fox?
Fair enough question. That is the name of the character that Charlie Sheen in the movie Wall Street played. And that character, Gordon Gecko, basically helped convince Bud Fox to make some bad decisions. And so I just thought we could stick with our theme today by calling him Dr. Fox.
Okay, fair enough. Sticking with Wall Street. Let's keep going.
All right, so Dr. Fox gets this unsolicited phone call from Mr. Gecko, who is running a large healthcare fund on the East Coast, and they want to add Dr. Fox and his surgical practice to their platform. Mr. Gecko sells Dr. Fox and how it'll be just a real simple deal. They've done hundreds of these deals, and what's going to do is going to help Dr. Fox with his exit of the practice of medicine. And Dr. Fox is like, okay, that sounds great. So he executes this letter of intent before speaking with any counsel because, he read it and it seems simple enough.
Okay, we need to have a button in here for the red flags that when they start flying that I can just give some sort of sound effect or something because I feel like you said it that way just to trip me.
Oh, maybe.
Okay, well, first of all, red flag number 1 was simple.
I did say that a few times.
Yes. Red flag number 2 was him just signing the letter of intent. I mean, we've had a few episodes, and I remember specifically with having Ben Hernandez on, and he talked about, kind of the issues that go into a letter of intent and why that's so important. But let's just, step back for a minute and visit about the letter of intent. What is the letter of intent? It is that initial document that you're trying to get on the same page of the material terms. And, this could be one of your trigger words because we joke that you get triggered by non-invasive. Well, you could get triggered on these where you hear the word non-binding. And of course, they are non-binding, but they are impactful. And so, the trap that Dr. Fox fell into was thinking, oh, well, this is simple, as you said, and, it's non-binding, and we'll get to the documents later. And so, who needs to worry about any of this? I'll just sign it and, kick the can down the road as to anything important that needs to be dealt with.
Unfortunately, Michael, in this particular case, you are correct across the board. I say only unfortunately because I want to be the correct person. But yes, everything you just said is absolutely correct. And everything you just explained is what Dr. Fox did not understand is that he locked himself up in certain deal points, even though it wasn't binding. It did handcuff us down the road as we talked about.
I have
LOIs.
a quick question too. I know in a lot of M&A deals they have some binding provisions in it. I don't know. If you recall, did they lock him up from, shopping it?
Yes. Yeah. So that was the big thing that he was not allowed to shop it once he executed. And so, going back to he signed this LOI and he thought it was pretty simple. They told him in a few weeks they'd have the final purchase agreement. So fast forward, they did. They got him these purchase agreements. And then Dr. Fox, so again, a very well-educated individual, he started trying to look at the LOI and figure out what it said, and then what did the purchase agreement said. And the good news in this case is he did hit that little button, and he stopped and asked for help. And that's actually when we actually got brought in. And, on the initial call, we spent a significant portion of it just trying to understand what did he think the deal was going to be, what was it told to him, and what was important to him.
Yeah, I'm curious. And how did all that line up with the letter of intent? Yeah,
not one of the major deal points he wanted was in the purchase documents, and certain aspects of the LOI didn't even match the purchase document.
Okay, well, tell me more.
All right, so perfect example of things that happened was the number of years that Dr. Fox was still going to have to practice under this new group was higher in the purchase agreement than was outlined in the letter of intent. They had a whole bunch of funds being escrowed that was never noted in the letter of intent. Michael, do you want to note to the audience what escrow means?
Yeah. And so, a lot of times when buyers are buying a practice in an acquisition like this, they want to know that they're getting what they think they're getting,
Mm-hmm.
and they protect against that risk by having a certain portion of the purchase price set aside in escrow and held in escrow for some period of time, sometimes months and even a few years, to where they can see what plays out. And if some of contingencies happen, they may be able to keep some of those funds, or if they go the way they're supposed to go, they get released to the seller.
Yep, all good points. So also never discussed in the LOI. They had a non-compete in the purchase agreement, which is actually pretty standard. The LOI said it was going to be a stock purchase agreement, and they moved it to an asset purchase agreement, which we'll talk about the difference in a little bit. But, worse, if you could even imagine, is that the asset purchase agreement had all this really heavy language on the reps and warrants that we only typically see in a stock purchase agreement, non-asset purchase agreement. So, we were representing Dr. Fox, and we went in and started negotiating with Mr. Gecko's in-house counsel. And unfortunately, we were able to make some modifications, but basically we kept getting the same line over and over again. These are the same doctors. These are the same documents. All our doctors executed. We don't make changes. And this dragged on for months. And we weren't going very far with this thing. And the demands that our client wanted, they wouldn't agree to. And basically, after a while, we just ran into a brick wall.
Straight out of the hospital negotiations playbook. This is the way we do it, and you will like it.
Yes.
Well, those are some pretty significant and material terms, and I'd like us to dive deeper in some of them on the second half of this episode, including, as you mentioned, the stock purchase agreement versus asset purchase agreement. And, of course, I'm curious and want to learn what happened with Dr. Fox and Gordon Gecko after this break.
Many business owners use legal counsel as a last resort rather than as a proactive tool that can further their success. Why? For most, it's the fear of unknown legal costs. ByrdAdatto's Access Plus program makes it possible for you to get the ongoing legal assistance you need for one predictable monthly fee. That gives you unlimited phone and email access to the legal team, so you can receive feedback on legal concerns as they arise. Access Plus, a smarter, simpler way to access legal services. Find out more. Visit ByrdAdatto.com today.
Welcome back to Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto, here with my co-host, Michael Byrd. Now, this season's theme is Zoom Out. As part of our Zoom Out theme, we talk about the bigger picture about what's going on, in this case, with private equity in the medical industry. So, Michael, what are some of your thoughts as we zoom out on this particular issue with private equity?
We alluded to it a little bit earlier, noting an increase in phone calls that we were getting, both from private equity companies themselves that are trying to explore, investing in medical services and different specialties, and from our practices who had received some sort of interest. And, my thoughts are that I think that there's a lot of money on the sidelines during the pandemic. Healthcare has been kind of a frenzy for a decade plus.
Yeah.
And there's been a lot of different areas that have attracted a lot of money. And so we're now just seeing, I think we're just seeing more and more interest in the provider side of healthcare. And I think, dentistry and dermatology and some other specialties kind of paved the way. And a lot of the trepidation that private equity may have had based on hospitals' attempt to do this back in the 80s, where they tried to acquire medical practices.
Did.
That was a fail. But that it's a different time, and I think there's some traction. I think physicians are more willing to be employees now than they were ever before. And that's such an important aspect for private equity, because they need the doctors to be employees, because they're the ones that have to treat the patients.
Totally agree with that. So let's just keeping with this zoom out moment. How do you think it's impacting the market, Michael?
I think it's driving valuations up. So, we did an episode in the past where we've alluded to how valuation works in medical practices. And, I guess just the main thing to understand is there's locker room talk out there that medical practices aren't worth anything.
Mm-hmm.
And, we've had to contend with that current against that premise when we've had doctors trying to sell their practices for years, for our entire career. And what we're seeing not only is, confirmation that there can be significant value in medical practices, but we're seeing deals that have unprecedented valuations compared to what we've seen in the past for a traditional medical practice.
Totally agree with that statement.
So I have a follow-up question for you as it relates to this story. You discussed that they switched this deal for Dr. Fox from a stock purchase agreement to an asset purchase agreement. I know we've talked about this in the past, the differences between a stock purchase agreement and asset purchase agreement, but talk about this and the overall impact for Dr. Fox.
Yeah, and I'll take a little bit bigger step back and then get into how it impacted Dr. Fox. But as a reminder to our audience who hadn't listened to our past episodes, the stock purchase agreement is an arrangement where you're buying the actual stock of the entity. So typically you're either buying it from the company itself or from the individual owners who own the stock. You're actually not buying any of the assets the entity owns, just the stock. And when you buy the stock, you buy everything it owns, including its debts and liabilities. While in an asset purchase agreement, you're actually only choosing which assets owned by that company that you're choosing to take. So I choose to buy this equipment, or I choose to buy this accounts receivables, or I choose to assign the lease to myself. You get to choose. It's a totally different concept. Conceptually being that when you go to a stock purchase agreement, you assume all liabilities unless you choose otherwise, while an asset purchase agreement, you don't assume any liabilities unless you choose otherwise. So let's fast forward back into our current situation where we have Dr. Fox. Dr. Fox is originally, he was going to have them basically assume all his liabilities, and that way when he was going to retire, they had all those liabilities, and so to him it made sense. It was great. When they switched it to an asset purchase agreement, and I know when you and I typically represent a individual who wants to purchase another individual, when we can, we prefer asset purchase agreement. And we can definitely get into that in a second, but let me stay on Dr. Fox's story. That meant they were pooling and choosing which assets they wanted to take, so like his lease and some of his employees and stuff like that. But that meant all the liabilities that were part of his practice prior to that purchase were all going to be still remaining for his liabilities. So his tax liabilities, his other employment liabilities, he still was liable for that. And he needed to make sure that he made sure that he had money set aside to take care of any of those liabilities. The other piece, though, is if I mentioned early on the reps and warrants, they were asking him to represent and warrant a whole bunch of things, which are typically not part of the asset purchase agreement, which meant they have it. If he said, oh, yes, I had a great compliance plan in place, and later on it turns out he didn't have a great compliance plan in place, they could hold that against him saying, hey, in your reps and warrants, this is not correct, which makes no sense typically in your asset purchase agreement. But again, going back to our Gecko in-house counsel who kept saying over and over again, well, that's how we always do deals. And so that was kind of the part that we kind of bumped heads on, that asset purchase, stock purchase agreement. I don't know if you have anything else to add that you thought of between the two.
Yeah, no. Well, for my first observation is that sounds a lot different than what his expectations are. There's a significant impact to Dr. Fox as it relates to him having the deal carved up from differently than what he was expecting. And I'm curious, what happened? Did he end up just signing the standard asset purchase agreement that Gordon Gecko required of all of his doctors?
Yeah, actually, no. After months of back and forth with Gordon Gecko's group, we actually narrowed the asset purchase down to just a few key terms and conditions that Dr. Fox had to have, or he wouldn't execute this deal. Gecko's group refused the terms. So we ended up having a long call with Dr. Fox, walking through his remaining options from everywhere from executing the agreement that's staring in his face to just basically terminating the transaction. And that was his options.
So what did he decide?
Well, I called Gecko's counsel and told them that we were sending an official notice of termination of the agreement, which was consistent with the letter of intent. And as a courtesy, I wanted to give him the heads up before he received it via U.S. mail and email. And there was this really awkward long pause from the attorney. And he said, basically, is he really walking away from this deal? He's getting paid $2 million at closing. How can he be walking away? My response was pretty simple. If you remember, Dr. Fox did not need this money. He was well off, and he would be happy to join their organization. But if these certain terms were not there, there was no reason for him to do it. So he decided to walk away.
Power move.
Mm-hmm.
The tables get turned on Gordon Gecko.
Yes.
So did the deal die?
Yeah, not exactly. About 2 weeks later to the day of the call, we actually inked the deal with the key terms that were important to Dr. Fox, which they never added to their agreements. My client got $2 million at closing for his solo practice, but Dr. Fox's ability to walk away from the deal was a significant advantage. Most physicians who Gordon Gecko's groups acquire, they're not willing to walk away from that kind of money. And the private equity, they pretty much know this. They were actually counting on the fact that greed is good. But our doctor was not tempted nor willing to sign anything they put in front of him this time, because if you remember, we had signed LOI early on. So Michael, as we get done with this incredible story of walking away from $2 million, but still getting the $2 million, what are some of your final thoughts?
I alluded to this at the beginning when I talked about the drop mic plan.
Mm-hmm.
We actually added this to our speeches because we have doctors who are like, I'm good. I'm practicing. I just want to wind my practice up. I don't need to sell it. I've gotten what I want out of it, and I really just want the freedom to control when I leave and to walk away. And so we just, in our speeches, said, okay, well, that's the drop mic plan. It's like I'm going to do my thing until I'm done and then drop the mic and walk off into the sunset. Now, there's stuff that goes into that, like making sure you don't have any liabilities and all that sort of thing. But what's fascinating here is he had that drop mic strategy and had all the financial resources built around that, to where when there was this unexpected opportunity that arose with private equity, he could just sit in that and use that as negotiating leverage that, what, if it doesn't work for me, I'll just go back to my plan A from the beginning. And once again, is a really powerful tool to take down the big, great Gordon Gecko.
Yeah, and that's a great point, Michael, is that a lot of physicians don't have that exit strategy in place. And so when an opportunity like this just shows up, they feel like they must take it. And again, going back to referencing Ben Hernandez, that unsolicited offer that we talked so much about to a lot of these individuals, all of a sudden $2 million and all I got to do is A, B, and C. That sounds so great. They don't realize what that A, B, and C is actually, A through quadruple Z. And so they don't realize what they're getting themselves into. But he had a plan. He knew that he was going to work through a certain number of years. He knew that he had put away the money that he needed to live a very, very comfortable lifestyle. And this was just, we call it lagniappe. It's a little bit something extra that he could put into his savings if he needed it, but he didn't. And I agree with the drop the mic is a very powerful ability that you can just walk away and you don't have to sell your practice. You don't have to find that next physician because you position yourself in your exit strategy to be your own boss, even to the day you decide to retire. Now, that doesn't mean that there isn't value there because he was able to get $2 million. And that doesn't mean that for our clients that still want to bring on young physicians to buy them out, that's not a great plan too. It's just these are the ways in which for him it made sense to him. And just to kind of fast forward the end of this story, he became a sensei like a lot of ours because the group knew that he was going to be with them for about 3 years, Gecko. And so they brought in a young physician early on to train underneath him to learn this very, very subspecialty of surgery. And so it was a win for the Gecko group and ended up being a win for our doctor.
All great points, Brad. And, earlier I mentioned talking about whether a medical practice has value and kind of the current we've had to swim against that private equity has helped solve. And I'm excited for our next episode because we're actually going to have someone on, a special guest who values medical practices and who does these deals. And we're going to learn a little bit more about medical practice value.
Yes, we are, Michael. So join us next Wednesday when it's Fake or Real, a medical practice has no value with Anna Brewer. Thanks again for joining us today. And remember, if you like this episode, please subscribe, make sure to give us a 5-star rating, and share with your friends.
You can also sign up for the ByrdAdatto newsletter by going to our website at ByrdAdatto.com.
ByrdAdatto is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does it establish an attorney-client relationship. Reference to any specific product or entity does not constitute an endorsement or recommendation by ByrdAdatto. The views expressed by guests are their own, and their appearance on the program does not imply an endorsement of them or any entity they represent. Please consult with an attorney on your legal issues.